Hey, welcome back, YouTube land. Hey, this is the Veteran Land YouTube channel. If you've come here, I hope you're ready to learn some really good stuff about VA disability. Hey, as always, I'm your friendly VA accredited attorney, Matthew Lang, here to provide you an educational platform with the hopes that one day we can make the VA disability process much smoother between veterans and VA alike. We have a lot of videos on our channel right now. We try to post at least once a week with different topics about the rules, the requirements, the processes of VA disability. It can be a lot of information, and I know. As somebody who's worked with VA disability since 2008, I know it can be a lot of information. I try to break a lot of stuff down the best I can. And in doing so, I've come to the realization that a good video might be this one. This one right here, where we're going to just give an overview of a majority of what we've talked about already in a nice little format so that you can understand better, well, VA disability from start to finish. So let me give you your overview, your guide here. We'll call it VA 101. I got my outline here on my trusty sticky note. My yellow pad was full. We've been busy. So let's just get down to it and let's go through this. Veterans, this is mainly for you. VA, still maybe a good refresher for you as well, and then you know it's being put out there. Veterans, we got to start with the foundation. What is VA compensation? Well, VA compensation is a monetary amount that's tax-free. Yes, tax-free. That's payable to you, veterans, if your current disability is related to your time in service. There are definitely eligibility requirements. Pretty much every veteran is eligible. There are a series of rules, though, when it comes to like Reserve and National Guard members that may make certain things not quite fit where we need to and may disqualify those individuals. There also may be stuff even for active component that may disqualify them. But understand the basics of the rule is that if you've served in any branch of the service, in the active component, the Reserve, or the National Guard, there are rules that say you could be eligible for VA compensation. So you want to file the claim. You served in the Army, the Air Force, the Navy, the Marine Corps, the Coast Guard, whatever branch it may have been, whatever service you served, and you've decided it's time to file that claim. Perhaps you've never filed it before. Well, veterans, here's how you would file it. We have a series of options. One, go to va.gov, set up your account. May not be the easiest thing to work with. Bit of a headache, but don't give up. Once you're through it, I promise, it's a nice little platform to work with. Once you're into va.gov, find the location where you can file your claim and submit your claim. The computer system is going to walk you through all the questions on the required form. It's going to create a form in the background that will be directly loaded to the VA system, where the VA will be able to establish that claim and get to work on it for you. Now, if computers aren't your thing, which they're not everybody's, you could go down to a local VA regional office, to their public contact section, and ask for some assistance. Go, hey, Mr. or Mrs. VA, I would like to file my original claim or a new claim for benefits. Could you help me complete that form? And they can get you the form, and they can help make sure it's filled out for you and then submitted to start the process. Now, perhaps you're a little bit more old school and you want to mail it in or fax it in. Well, you can definitely get a copy of the VA Form 21-526EZ if this is your first filing or you're filing a new claim. You can fill it out by hand, and well, you can do that. You can fax it to the VA or you can mail it to the VA. The last option I can think of right now in order to file your original claim, veterans, is, well, you can seek out a veteran service officer. You can seek out an accredited agent who is handling new claims, or you can seek out an accredited attorney like myself who is handling new claims. Now, as the laws stand at this moment, new claims are not something we're allowed to charge for. So understand that if you come to, say, myself, we'll sit and help you complete that claim, fill it out, and file it for no charge. Same will happen with a VSO. Same will happen if you do it on va.gov. Same will happen if you go into the public contact area of a VA regional office, free of charge. Now, other charges may apply later on. So keep that in mind, because there are individuals out there charging you for your first claim, which, well, until our government passes the new laws, is not allowed. So that's how you file your first claim, veterans. That's how you file. So now you're going to probably realize that there's prompts in there of evidence uploads, and do you want to submit things? Well, what kind of evidence do you submit? What do you need? Well, veterans, the VA is going to have a duty to obtain your federal records, like your service treatment records, perhaps your service personnel records. If you've done any treatment at a VA facility, those are in their custody. Those are federal records. They will have to search their database and find all those records and get those for you. You don't have to do any of that part, but if you do have copies, help the VA out. Go ahead and file those with your claim. Get it all in your file right away. Now, VA could also, with your authorization, veterans, obtain medical records outside of the VA. They call them private treatment records. So if you have a primary care physician that is outside of the VA and you want those records to be part of your claim, you could fill out the authorization form and the VA will try to get those records for you. But ultimately, it's going to be your responsibility, veterans, to get that information to the VA, to submit those for your claim. Now, outside of these federal records, these service records, and these medical records that may be needed to prove your claim, veterans, you can provide personal statements. You experienced it. You know best. You were there. Help the VA out. Paint the picture. Just don't get carried away. We don't want to get lost in the weeds there on your statements, but we do want to make sure the picture is painted. You can also ask friends and family and other service members to write buddy statements. All this is known as lay evidence. They can write to what they've observed, how your condition affects your everyday living, how it's affected you since service, what they witnessed in service. Maybe they've seen the injury that occurred, the event that happened that led to your condition. This is all evidence that you can submit. Now, is it all needed all the time? No. But that's for you to decide, veterans. You and perhaps your representative decide what is needed. What is needed to support your claim. And those are all the pieces of evidence that could help. Medical evidence, lay evidence, military records. Oh, and something else I forgot that's become very popular lately. You could, veterans, ask a private physician for an independent medical opinion if you feel that's needed to place into your file. You could ask for them to do certain VA examinations outside of the VA, as we call them, DBQs. And you can already prepare that all for the VA to help reduce the backlog so they don't have to make that request if all that evidence is adequate for rating purposes and backlog the contractors and the VA facilities even more than they already are. They could expedite your claim. So now that you've filed your claim, you've got all your evidence figured out, it's all there. VA is going to go through the process, veterans, of making sure that all the rules and regulations that apply to them are followed. Duty to notify, duty to assist, and so forth. Well, at least they're supposed to. Mistakes do happen, understandably. But let's say everything got done. Let's say you get that service connection for your disability. So what if? What if you do? What does that mean? Well, at this point, veterans, after the review of all your evidence, all the duties are completed, VA renders that decision, they make the determination that your condition, say a back condition, is service connected. Well, then they take and they determine what the evaluation is going to be based upon the rules, the laws, the rating scheduler. And they're going to assign that evaluation. They're going to go through the rules and laws again and assign an effective date for that evaluation. In most cases, it's going to be the date of your claim, depending on other potential exceptions that could apply. They're going to do all that. They're going to put it all together in a decision, and then they're going to send it out to you in what, well, I know is a notification letter that tells you what your appeal rights are, what decision was made, and so forth. Now, maybe you've got more than one condition on there. 3, 4, 5 conditions you got service connected for, veterans. But you look at that decision when it comes to you, and you go, well, how am I not getting more than that? Doesn't 1 + 1 equal 2? Well, then we have to remember in the VA disability world, there's this thing we call VA math. Well, all these years, 1 + 1 always equal 2. And if it doesn't make sense, it must make sense for the government. So 1 + 1 may equal 3 now. Maybe it equals 0.5. I don't know. The point is VA math comes out as the idea that they're looking at veterans, what is left of you as a whole. So if there's 10% of, you're 100% to begin with, and if there's 10% of you gone, your new 90% is your new 100% of you. And we start doing some calculation that, boy, I got a video on it, check it out. It's just one way of looking at it and how to calculate it. I've seen others out there do it differently. That's math. It can always be done more than one way. But check that out if you want more detail on that. I'm not going to get you lost in this video on that one. But just understand that your percentage is not based on just 1 + 1. VA is going to do this VA math to come up with your combined evaluation. But let's say it's not service connected. Well, why would it not be? Why does VA deny claims? Well, veterans, VA could deny your claim because the evidence may just not fit. The evidence you provided may be missing something. Maybe the whole picture wasn't painted, or enough of the picture was painted for the VA to understand. Think about it this way. The VA is only receiving pieces of paper, or, well, digital pieces of paper now, as to who you are, what you've done, your history, your condition, when it started, how it may have started. There may be a lot of gaps inside that evidence. And if there are gaps in that evidence, well, VA will likely have to deny your claim because it can't meet all the elements that are required by law to give you that service connection. That's one reason VA would deny. Now, it's unfortunate that, again, mistakes do happen. VA could deny completely incorrectly. Maybe they forgot to follow a duty to assist. Maybe they didn't understand that that exam was inadequate based upon court rulings and the law. And they denied you anyways when they shouldn't have. That could be a reason for denial. Another issue of denial that I hesitate to even talk about that I've seen over and over could also be the idea that there may be a pressure. There may be pressure on the decision maker to push a decision out because they are required to complete a certain number of claims a day. And the office is also required to complete a certain number of claims a day, a month, a year. The pressure gets tense. As somebody who's been there, I know. The pressure gets tense. And I have seen it cause denials in the way that the decision maker will not review all the evidence and, in fact, We've got quite a few back here today from this push as we reach the end of the fiscal year, where the denials clearly are just copy and paste of each other and no actual review of evidence. So you could be denied incorrectly, veterans, for, again, the lack of evidence supporting your claim, for a misunderstanding of the rules or the laws before denying, or even perhaps the pressure of got to get a claim out and make those goals. So when you are denied, veterans, when you are denied, what's the process? How do you appeal? Well, like I mentioned, those appeal rights are all inside of that letter. There's some good information in there, actually. I know the letters can be very daunting, a lot of pages, and you're looking at it wondering, what is this? Well, just take a moment, sit down, think about it slowly, read piece by piece if you need to, take a break if it becomes too much for you, and then come back to it. But what I'm going to do in short here is tell you, well, how can you appeal? If you're denied, veterans, or even if you are service connected and you disagree with the evaluation and think it should have been higher, or maybe the effective date is off, you can appeal any one of those issues. To do so, you get three options. Three lanes, as I'm going to call them. Well, the first one is going to be a supplemental claim. You can say, wait, I realize now that maybe that full picture wasn't painted. Maybe I see, maybe there was a piece of information or detail that got left out that I didn't realize how important it was, or I thought VA already had it and they're telling me they don't. You can submit the additional evidence, veterans, on that supplemental claim. You can provide that on the supplemental claim for the VA to consider, review, and process the claim again. Now, keep in mind, all these options I'm going to give you, you only have one year, except for the supplemental claim. You can file at any time. But if you don't file within 1 year, you potentially lose the earlier effective dates. Now, your other option is a higher level review. Well, the higher level review goes up to, well, a decision review officer instead of like the supplemental claim being a rating veterans service representative or a rater. So this person is supposed to be more skilled, they're paid more, they're supposed to be more knowledgeable. And what you want them to do, veterans, on a higher level review is say, the evidence of record supports a decision that is opposite of this denial. It supports the grant. Or not only that, perhaps this denial was premature because there's a duty to assist error in the use of using an inadequate medical opinion by the VA in order to deny the claim when it should have been sent back for a new opinion. So this decision review officer will make a determination. Based upon the evidence in file at the time of the claim, you can't submit any more evidence. Now from there, if they find there's a duty to assist error, they'll shoot back down to the supplemental claim level. Development will be done, new exam will be gathered, whatever was necessary should be completed. Then a decision will be granted or denied or deferred. Who knows? But the point is another decision comes out. From here, you're going to get the option again, veterans, supplemental claim, higher level review claim, or this last option we haven't thought of yet. So even if you're denied on the higher level review, you can still have another option. You can even come back to the supplemental claim level. Perhaps the decision review officer missed that duty to assist. They got in a hurry. Maybe they didn't understand the inadequacy rules. They re-denied the claim for the same reasons, and then you got to come back to a different angle. Maybe a supplemental claim, or this last lane you get, the Board of Veterans Appeals. So the Board of Veterans Appeals is our first administrative body, appellate body in the VA. This is where, for the first time, veterans, you will encounter attorneys and judges making a decision on your claim. The VA level is, again, not individuals typically educated or experienced in interpretation of law or the legal field at all, except for the on-the-job training that may be provided by other non-legal professionals. So that's the big difference right there. The Board of Veterans Appeals, you actually get attorneys and judges looking at your claim. Now, when you file to the Board of Veterans Appeals, you have a few options. You could file on their direct docket, which says, Judge, attorney, all I'm asking is for you to look at the evidence as it stands without any new evidence and reverse the prior decision. Maybe even remand it back down to get the proper medical opinion or development completed. Or you can go through an evidence lane. Maybe you just don't think the VA is at the lower levels looking at the evidence properly. So when you submit new evidence for your appeal, you can say, BVA, judge, attorney, please look at this new evidence along with the evidence that was already in file and reverse the prior decision. The third option you get is a hearing. You can have a hearing with a judge, in person, virtually, typically. And you can give testimony at this point, veterans. Now, you have to remember, though, the testimony has to fit the elements required for service connection, if that's what you're arguing. The testimony has to be relevant. It's not going to probably do you any good, and this is something you can talk to your representatives about if you have them. It's not going to do any good just to kind of go off into the weeds in the story. You got to make sure that your testimony fits the elements that are required. But it's an option. So let me recap that really quick, because there's a lot of moving parts in the appeal world. And if you do need representation, I would recommend it, veterans, because of all these moving parts. And you get your choices out there again, VSOs, accredited agents, accredited attorneys like myself. You choose whoever you're comfortable with. But the main point is you got three appeal lanes. You have supplemental claim, provide more evidence, get a new decision. Higher level review, evidence that's on file. And what I forgot is there's an informal conference piece that could be in there, if you select that as well, where you can, well, just talk to a decision review officer and hope that they talk back and understand what's in your file. Sorry, I should have left that one out. It's there now, but that's been my experience. Let's move from there. Then you get a Board of Veterans Appeals, the BVA, where again, you get three options: direct, evidence, or hearing. So that's it. Supplemental claim, higher level review, Board of Veterans Appeals. Now, if we go beyond that, if you get denied at the Board of Veterans Appeals, there's motions to reconsider, there's the CAVIC above it, the Court Appeals for Veterans Claims, and above them, there's the Federal Circuit, and that we just keep going. But the main three: supplemental, higher level review, BVA, Board of Veterans Appeals. So, how do you appeal? Well, it's kind of the same way, veterans, as filing your claim. You can go on the va.gov page. You can make the selection of what appeal form you want to complete. You can complete that, and it'll send it through the system. You can, again, do it in person with a VA public contact representative at the local office. You can do it with a VSO. You can do it with a great attorney, with a great agent. You can print out the form. You can fill it out by hand. You can mail it or fax it to the VA. So your options are really the same as the original form filing. Well, let's say you go through all this, veterans. You go through all this, and you get all these conditions service connected because that's what you're entitled to. Well, we got to remember that there may still be points where VA can take away benefits. So the biggest example I've got that I think throws veterans off the most is the rating scheduler for cancers. Typically has a requirement that makes that 100% temporary as long as that cancer is active or being actively treated. Then there's a mandatory examination, VA examination, that's usually needs to be requested to determine what the residuals are after a certain period of time, or after there's evidence that the cancer may no longer be active or no longer being treated. So that's one way your benefits could be reduced, veterans, just because the law says that's the way it works for that condition in particular. Now, it could also be that the VA mistakenly service-connected those conditions. Maybe they mistakenly gave an evaluation that the evidence didn't support, and they find that there's a clear and unmistakable error, and they could propose to then take those benefits away or reduce them. Could be that somewhere along the line it was discovered that the claim was fraudulently filed and the VA service connected. Now they know of the fraud and they can take that claim away. So the point is, there's definitely a few different ways where the benefits could come down. I think the last one I'm missing there is the idea that there's sustained improvement in your condition, veterans, or that there's likely to be sustained improvement. And we got all those issues there, and that's a bigger section as well. But even though that the VA can't take away your benefits, there are protections in the law. We've talked about them before, things like this 5-year rule, the sustained improvement for VA examinations, for medical evidence showing that improvement. There could be this 10-year rule that says you can't sever any benefits unless there is fraud after they've been in place for 10 years. There's this 20-year rule that says, hey, unless there's fraud, you can't reduce that evaluation or take that benefit away that's been in place for 20 years. We also have other things other stipulations and exceptions that apply when it comes to like future exams for proving that sustained improvement. There's this thing that many know is probably the 55-year rule. This is when you reach 55 years of age, it's possible the VA is not allowed to give you a future examination and they have to deem the condition permanent in most cases. So that's a summary of that. There's a lot going on there. But now, if the VA does decide to take away any benefits, veterans, there are due process rights. These are constitutional rights provided to you. The due process must occur. You will get a letter in the mail from the VA. You'll have 30 days from the date of that letter to request a hearing if you want to provide testimony about why the VA should not make that decision to reduce your benefits. You'll also be receiving a total of 60 days to provide any additional evidence to help support why the VA should not make that decision in reducing your benefits. From there, you lead into another decision, and then you fall back into potentially appeal rights if the VA follows through with their decision. So let's say all the craziness is over with. Veterans, there's no proposal reduction. There's no future examinations. You're 100%. You are 100% overall combined. That's that. Well, is it? Here's where the question really lies then. Am I permanent and total? Total and permanent? I've heard said both ways. I'm familiar with calling it permanent total or P&T. Well, check this out, veterans. 100%, that's your total line. 100% total. That's as high as the percentage goes. So once you reach 100% in total, but is it permanent? Well, what you have to ask yourself now, is there anything inside the record that shows potential improvement where the VA has established what they call a diary for a future examination to determine if it is permanent? If there is no finding of a likelihood of improvement, there's no examination scheduled for the future or diary set, it's likely that you're permanent. That 100% will remain where it is and never be looked at again unless you request it to be looked at again or file something else. Now, how do you really know if that's the case? You know, I would say one of the easiest ways is to go to your benefits letter, have it printed out off the va.gov site or the VA app, because it will actually tell you on the letter whether you're permanent and total. Now, what if you are permanent and total? Well, you want to check with your states. Each state has a series of other benefits, typically for veterans who are 100% permanent total. A lot of times you may get some sort of relief on property tax, car registration taxes, hunting and fishing licenses, state park entrances, and so many more other things. Now, outside of the state stuff, whether you're 100% or not, are there other benefits? Well, sure. You may be entitled to a special monthly compensation. Perhaps you have a loss of use of a creative organ, which is the most common thing we see. Well, you'll get your evaluation for the condition, and then you'll get the additional for the SMC. So it'll be additional payment on top of your service-connected payment, your evaluation. You might get SMCS because you're 100% and you have a combined 60% as well, so statutory housebound. You might get an SMCL because the evidence shows that you're in the need for aid and attendance. Maybe you'll get an SMC for some other reason. But the point is there are special monthly compensation rates out there for more extreme issues outside of what the rating scheduler gives for your normal percentages. Now, we don't have to stop there. Veterans, the VA has all kinds of benefits, service-connected or not. But if you're service-connected, especially at 100% permanent total, you get free health care from the VA. Now, there's different levels on percentages, but you're going to get health care from the VA. You may get education benefits for your dependents. You may have education benefits still applicable to you from like GI Bill. You may get a home loan benefit. That's not even part of the disability side, but you could have waived fees because of your disability. So you want to look into everything. Be knowledgeable. Check with your states. Go to the VA website, va.gov. Look up all these. That information is so robust. It's everywhere. It's all over out there. Whew. What do you think, veterans? Does it all make sense? I hope it does. I wanted to give you this overview from start to finish. I wanted to give you the basics of what VA compensation is, how to file it, whether you could be eligible or not, what evidence could be helpful to you, what you may need to prove your case, the appeals process, the other benefits that could be out there for you, where to look for all those. I wanted to give you as much as I could in this overview. Understandably, though, VA law is very, very complex in the idea that there are multiple laws, there's multiple benefits. But I think the easiest way to remember VA law is the basic foundation. When it comes to VA compensation, I think you're in a good place if you can always remember three criteria, the foundational criteria as I call them. In-service event, current condition, and a nexus, or a link between the current and the past. If your evidence can support all that, well, service connection, here you come, and all these other benefits may also apply to you. Veterans, as always, and VA employees, if you want to hear more about certain topics, feel free to throw them in the comments. I will get them recorded and out to you, that knowledge to you. Don't forget, again, va.gov is a very good resource, has quite a bit of information there. You can also seek out any representation if you need for your claims. Veterans, it's not a requirement, but many times it's very beneficial to you. I would recommend that they're accredited, BSO, accredited agent, accredited attorney like myself, who can also help walk you through this process, understand a lot of these laws, argue these laws for you, these rules, and make sure that your claim is granted as long as the evidence supports it. Well, I thank you, everybody. This has been a longer video than usual, but I thank you for sticking out. If you did, please feel free to go back, review anything that was in this video, rewind, pause as you need to. It's a lot of information, but until next time, I'll see you Tuesday. with more VA disability.